Good morning. The other day I was a little bit hurry to explain the implementation of newly enacted BNSS BS Act. But later on search, I learned that the proposed acts will be implemented on notification, and that notification will be late by 2024 December. So 1 year more is there. So I understand that when I was studying LLB, first year at Chhattisgarh, then in Madhya Pradesh, Ravi Shankar Shukla University, Surana Jain Law College. So my one of the subject of criminal procedure code was 1898 CRPC, not 1973. Though I was studying law in the year 1977. So then thereafter I have been transferred to Nagpur, Maharashtra. So there I started second year law. Then their syllabus was 1973 CRPC. So I have to write and rewrite the examination of Code of Criminal Procedure twice. And that is equal committee is there at every university. Forget about that. Therefore, even when I started practice in the year 1981, I came to know that 1981 only CRPC was implemented. Therefore, you have to be careful to understand the law and other things. Here, yet another judgment, AR 2023 Supreme Court, 5652. Yaspal Jain and Susila Devi and others, understanding that there are multi-number of civil cases pending before various courts, and particularly the case referred was 43 years. The Supreme Court has given certain directions as to how trial of civil courts are being conducted. They say all courts at district and taluk level shall ensure proper execution of summons in a time, that Order 5 Rule 2 CPC. Then they have to collect the statistics and forward the same before the committee constituted by the High Court for its consideration monitoring. Then they say a court should ensure that Order 8 Rule 1 written statement is filed within time. Then next question is important for young lawyers as well as the other exam pursuers, that the third direction was, they say you must initially, after filing written statement, consider what all are the admission, what all are the denied, and advise for 89(1) for settlement. And if there was no settlement by ADR, alternate dispute resolution, then commence the trial next day and would proceed day-to-day basis. This is what they say. Then they say under rule for the direction 4, frame issues open court within 1 week. Then they say fixed date shall be in consultation with the advocates for the parties to enable them to adjust their calendar. Then once the date is fixed, it should be day-to-day basis. Then they have to maintain day-to-day diary, and they have to fix only few number of cases to avoid overcrowding, and only after completion of that trial only the other cases be listed. This is also something new. Then they say the bar associations and bar councils should prepare periodical refresher courses and by virtue mode. Then they say once the trial is completed, it should be say they said the day to day that is already there. Then while fixing costs, some directions were issued. Therefore, this will be, and they say as per after completion of oral argument, the judgment should be pronounced within 20 stipulated order 20 series. Then the judges 5 years pending cases should be reported to the High Court. Then all these committee appointed by the High Court should sit once in 2 months for further steps. Kindly take down this, keep this copy with your file and record.